पार्टिसिपेट नमस्कार सर. नमस्कार आव्हाड सर. चालू करायचं सर.
नमस्कार.
हा नमस्कार. चालू करायचं.
होय.
हा 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 आव्हाड सरांचं आळंगेज. हा नमस्कार. आळंगेज लॉ क्लासेस सोलापूर तर्फे मी सर्वप्रथम डॉक्टर. हा चालू करायचं. मी थोडस चालू करायचं. मी थोडस पहिल्यांदा आव्हाड सर स्वागत आणि थोडस परिचय करून देतो आव्हाड सरांचं. सर्वप्रथम मी आळंगेज लॉ क्लासेस सोलापूर तर्फे मी सुधाकर आव्हाड, डॉक्टर सुधाकर आव्हाड यांचं. हे आवाज बदल.
कुठला आवाज येते?
थोडासा आवाज येऊ लागला. डॉक्टर सुधाकर आव्हाड ऍडव्होकेट यांचं मी स्वागत करतो. थोडक्यात मी ओळख करून देतो त्यांचं. खरं म्हणजे पूर्ण महाराष्ट्रामध्ये वकिलांना आव्हाड सरांचं ओळख करून देण्याची गरज नाही. ते स्वतःच्या कार्यकर्तृत्वामुळं.
नो व्हॉइस. एक मिनिट व्हॉइस येत नाही.
व्हॉइस येत नाही म्हणून लिहित.
हॅलो. हा येतोय.
आव्हाड सरांच्या स्वतःच्या कार्यकर्तृत्वामुळं ते पूर्ण महाराष्ट्रात नव्हे तर पूर्ण भारतात सर्व वकिलांना परिचित आहेत. तरी परंतु आपल्या कार्यक्रमाचं एक रूढी परंपरेपणे मी त्यांचं थोडक्यात ओळख करून देतो. माझे मित्र सुधाकर आव्हाड हे SSC परीक्षा 1970 साली, म्हणजे मी त्याच वर्षी पास झालो. आणि 1977 ला मी LLB शिवाजी विद्यापीठातून पास झालो आणि सर पुणे विद्यापीठातून सेकंड थर्ड ला रँक मध्ये आले. मीही सोलापूर शिवाजी विद्यापीठातून विद्यापीठात 3 वर्ष फर्स्ट क्लास फर्स्ट आलो. म्हणजे आमचे दोघांचे जवळजवळ शिक्षण 10वी LLB आणि LLM देखील मी 79 ला पुणे विद्यापीठातून मी एक्सटर्नल झालो एवढंच. पण सर मात्र रँक मध्ये LLM पुणे विद्यापीठातून उत्तीर्ण झाले. आणि त्याशिवाय 77 पासून त्यांनी वकिलीचा व्यवसाय चालू केला. गेले 44-45 वर्ष ते सर्व क्षेत्रामध्ये वकिलीचा व्यवसाय करतात. आणि ते वकिलीचा व्यवसाय करत असतानाच ते आव्हाड लॉ क्लासेस या माध्यमातून विद्यार्थ्यांना मार्गदर्शन करतात. सर्व LLB, LLM, JMFC, DJ याशिवाय लॉच्या परीक्षेचे सर्व मार्गदर्शन त्यांनी 1977 पासून आजपर्यंत विद्यार्थ्यांना करत आहेत. आणि विशेष सांगायचं म्हणजे त्यांचे मोठे बंधू कैलासवासी भास्करराव आव्हाड हे सुद्धा आमचे गुरु होते. आणि त्यांनी सुद्धा वेळोवेळी आम्हाला मार्गदर्शन केलं. गेल्या 10 वर्षापूर्वी मी एकदा सोलापुरात मोठं कॉन्फरन्स भरलं होतं. त्यावेळेला देखील 400-500 वकील लोक हजर होते. त्यावेळेला मी नुसतं साधं फोन केलं सुधाकर आव्हाड सरांना. ते लगेच फोनवर हो म्हणले आणि त्यांच्या स्वतःच्या खर्चाने सोलापूरला आले. आणि त्यांनी इंडियन एव्हिडन्स ऍक्ट वर जवळजवळ 2-2.5 तासाचं मार्गदर्शन केलं होतं. मला वाटतं 2009 साली इथं आले होते आमच्या कॉन्फरन्स मध्ये. आणि आज मी त्यांना अमित सरांनी फोनवरच विचारणा केला असता त्यांनी लगेच हो म्हणलं. आणि हे आमच्या क्लासेसला वेळोवेळी ते मदत करतात. आणि नुसत्या फोनवर देखील आम्ही त्यांना विनंती केलं तरी देखील ते या ठिकाणी आलेले आहेत. आणि त्यांचं 1998 ते 2003 पर्यंत ते बार कौन्सिलवर सदस्य म्हणून, महाराष्ट्र बार कौन्सिल सदस्य म्हणून निवडून आले होते. आणि त्याशिवाय 2002 व 3 या दरम्यान बार कौन्सिलचे चेअरमन पद त्यांनी भूषवलं. आणि पूर्ण महाराष्ट्रभर त्यांचे वेगवेगळ्या लॉच्या विषयावर बार काउन्सिल, लॉ कॉलेजेस आणि इतर ठिकाणी मार्गदर्शक व्याख्यानं, हजारो व्याख्यानं झालेले आहेत आजपर्यंत सांगायचं म्हणजे. आणि महाराष्ट्रातला प्रत्येक वकील त्यांचं व्याख्यान बऱ्याच वेळेला ऐकलेलं आहे. त्यांचे हजारो विद्यार्थी आज वकिली व्यवसाय करतात. हायकोर्टामध्ये हायकोर्ट जजेस सुद्धा झालेले आहेत, डिस्ट्रिक्ट जज झालेले आहेत, 250 पेक्षा जास्त JMFC सुद्धा झालेले आहेत. आणि त्यांना PhD सुद्धा पुणे विद्यापीठातून मिळालेली आहे. आणि असं अकॅडमिक आणि ॲडव्होकेट प्रॅक्टिकल एकदम तज्ज्ञ असे महाराष्ट्रातले एकमेव ॲडव्होकेट आहेत. आणि त्यांचं आज आपल्या क्लासेसमध्ये मी पुन्हा एकदा स्वागत करतो. आणि जास्त वेळ न घालता त्यांचं लेक्चर सुरू करावं असं मी अमित सरांना सांगतो. अमित सर सांगतील पुढचं.
आळंगीज लॉ क्लासेस तर्फे मी माननीय आव्हाड सरांचं ह्या ठिकाणी स्वागत करतो. आव्हाड सरांनी आमच्या विनंतीला मान देऊन वेळात वेळ काढलं आणि अतिशय लागलीच 2च मिनिटात ते तयार झाले आणि म्हणले की मी नक्कीच विद्यार्थ्यांना मार्गदर्शन करणार. आणि इलेक्ट्रॉनिक एव्हिडन्स हा विषय त्यांनी दिला, त्याबद्दल मी त्यांचेही आभार मानतो. आणि आव्हाड सरांना विनंती करतो की आपण आपल्या लेक्चरला सुरुवात करावी. सर
नमस्कार. नमस्कार आळंगे सर. नमस्कार अमित सर.
येस, नमस्ते सर.
My advocate brothers and sisters, I'm very happy to be with you all this morning. I'm really grateful to Senior Alange sir and Amit sir for allowing me to address this galaxy of the lawyers. I'm given to understand by Amit sir that most of you are appearing for judges examination and some of you are advocates but not appearing for the examination. Friends, at the outset, I will say that Amit sir discussed with me regarding the topic to be discussed on this platform. The subject of electronic evidence has been given to me at the instance of Amit sir. Nevertheless, I have to address this galaxy of the lawyers on the backdrop of your examination pattern and not only the electronic evidence. Let us see step by step and then we'll come to the end as to electronic evidence. Friends, as a student of law and to be aspirants to appear for the JMFC examination or judges examination, I will tell you one thing, that to appear for such judges examination and to prepare for such examination, you have to keep in one thing in mind. Always prepare in such a way that you know the entirety of the subject. Friends, when any enactment is made, any law is made, then while drafting such a law, it is articulately drafted, it is meticulously drafted, and there is an interrelationship between various provisions of the law. It is interwoven, and this interwoven or continuity of the provisions of the law we must understand at the outset before entering into the sections. Before entering into sections, you should know two things. First, classification of the provisions or classification of the sections, and secondly, nature of the law which we wish to discuss. Say for instance, friends, when we wish to discuss constitution, we go to reading of the preamble. Why? Entire philosophy of the constitutional jurisprudence is to be found in the preamble. Likewise, to understand any law, you must, as a student of law, and especially when appearing from judges examination, first you have to classify the provisions of the Act. Once you learn this is a trick. There is nothing difficult. It is just a trick. You have to develop that trick, how to classify the provisions of the law, and then to understand nature of the law itself. Once you understand these two things regarding any law, then further discussion becomes simple. Further reading becomes simple. Further understanding becomes simple. Further reproduction becomes simple. And therefore, to understand today's law as to electronic evidence or Evidence Act in general, let us first see as to the nature of the Evidence Act itself. This law, that is the Indian Evidence Act of 1872, is to be understood with reference to its nature. Let us see its nature. Someone will ask me a question, sir, what is it has to do with the electronic evidence? Yes, it has to do, because if you read the recent judgment delivered by the 3 judges bench of the Supreme Court in case of Arjun Khotkar versus Kailash Gorantal, then you will find nature of the law, classification of the provisions, definitions of certain aspects are very material, as has been stated in that judgment of the Supreme Court. Justice Nariman of the Supreme Court, while delivering that recent judgment, has taken this glossary of the provisions and nature of the law, including the classification of the provisions. And therefore, friends, let us commence our discussion into this today's arena or the subject with reference to nature of the law. And to understand nature of the law, first we must read preamble. Unless we read the preamble, we may not be in position to understand what is the law yet to follow. First page itself gives us idea as to what next pages are comprising of. And therefore, today's subject as to the Indian Evidence Act, its preamble provides for 3 aspects. And these 3 aspects are so as to consolidate, so as to define, and so as to amend law as to evidence in India. So what is the scope of the preamble? The scope of the preamble is provided here with reference to consolidate, to define, and to amend law as to evidence. What is to consolidate? Why the word consolidate has been used? When Parliament uses such phraseology, when Parliament uses such terminology, there is something in the mind of the Parliament. Otherwise, they are not similar words. They are words having some qualifications. When the word consolidate is found to be incorporated in the preamble, what it means? To consolidate means what? To put together. To define means what? To make a fresh provision. And to amend means what? To amend the existing law. Friends, therefore, as aspirant for this examination, you should know this first part of the nature of the law, that is the preamble. Preamble, therefore, relates to consolidation of then existing law, then to define, to make the new law, and to amend the existing law. You'll find here, what was the law then? That is to be consolidated, because this law of 1872 passed during the British period. The legislators, the Britishers, thought it fit. First, what is the existing law? And then existing law is what? Then existing law at that time in the year 1872 was, firstly, the Muslim law on the point. Then second law was various regional laws in different parts of India. Britishers thought it fit to borrow something from this. So all regional laws and existing laws were put together. And then the Parliament thought it fit during British period that let us add something to this. So that is defined. New provisions, they have been introduced. Fresh provisions, they have been introduced in this law by this Evidence Act. And thirdly, to amend. It was thought fit that certain provisions in the old laws were very good, but they needed some extension. They needed some amendment in the light of the growing needs of the society. And therefore, this law, to begin with, provides for 3 aspects: to consolidate, to define, and to amend the law. This is the consequence. All existing laws plus new laws plus amendment is our today's Evidence Act of 1872. Second issue as to nature of the law is to be understood. Almost all you being the aspirants and have studied the law in detail, in your classes as well as in the colleges. Laws are divided into two parts: substantive law and procedural laws. Substantive laws, as you have understood, that creates rights and duties, while procedural law provides for the procedure in the courts for enforcement of substantive rights created by substantive laws. So there are two systems. Question is, what sort of today's law is? Is it purely substantive, or is it purely procedural or not? And friends, today's law is neither purely substantive nor purely procedural. It is said to be an adjective law. Therefore, this is the admixture of the two. However, there are some provisions in this law which are purely of substantive law nature. Therefore, this is the admixture. And what are the provisions which are of substantive law nature? If you go to the provisions in section 115, 116, and section 117 as to estoppel, you will find those are of the nature of substantive law. Therefore, friends, at the outset we'll say some provisions of this law, they are substantive, some are procedural, and therefore there is admixture. It is not purely substantive, not purely procedural, and therefore this is said to be an adjective law. Third aspect of this Evidence Act, we must know in the beginning, is this is said to be, as per Latin language, lex fori law or lex fori law. What is this lex fori or lex fori law? And you will find there are various principles of Latin law as to jurisdiction of the courts or application of the law. Of such various principles as to application of this Indian Evidence Act, it is lex fori, means place where the forum is constituted. Usually, personal laws are applicable to every person, but the court's procedure is regulated by the place or the country where the court is established. So let us explain this in little detail. Say, for instance, there are two Hindus residing in United Kingdom, and there is a dispute between two Hindus over the property. One of them intends to file a suit for partition in English court. They are Hindus. Which procedure will be applicable? Which law will be applicable? English Succession Act? English Evidence Act? Then you will find, as far as Hindu law is concerned, we know the first principle that Hindu law is a personal law of Hindus, and every Hindu carries a law with him. Therefore, when that person, he traveled from Pune to London, then in his bag, he carries the book on Hindu law itself. Succession Act is impliedly carried by him to London. So English law is with him. Hindu law is with him even in London. But when dispute arises as to Hindu law, he files a suit in the court. Which procedure will he say that my Hindu law is applicable? Apply my own Indian Evidence Act in English courts? No. For your succession, Hindu law is applicable. Your law is applicable. But for court procedure and in respect of the recording of the evidence, the Evidence Act of that place will be applicable. Let us take case otherwise. Say, for instance, there is a dispute between two English people in India. Which law will be applicable? The law as prevalent in England will be applicable in respect of their succession matters and others. What will be procedure followed? English Evidence Act or Indian Evidence Act? And you will find here Indian Evidence Act will be applicable. Indian Evidence Act will be applicable irrespective of the nationality of the persons, even though their law will be applicable in India, but with the help of this adjective law system, that is the Indian Evidence Act. This is the beauty of Indian Evidence Act. Therefore, it is said to be the lex fori or lex fori law. Then comes the next consequence as to the basic law, basic principles. There are three cardinal basic principles. Every person, every one of us should know what are the basic principles of succession law. Indian Evidence Act. And there are three basic principles of Indian Evidence Act. These three basic principles of Indian Evidence Act are, firstly, that evidence is to be given in respect of fact in issue and relevant facts only, and of no other facts. So that is the limitation, that is the embargo as to recording of the evidence before the court. evidence to be given only of facts in issue and relevant facts and of no other facts. This is the first cardinal rule. Second cardinal rule is regarding oral evidence. Hearsay evidence is not allowed in the court. Hearsay evidence is not allowed in the court, so as to restrict the operation and application of the provisions of Indian Evidence Act. And third is very interesting, that while recording evidence in the courts, as per the Indian Evidence Act, the rule applicable is the best evidence rule. What is best evidence rule? It is said that if you have got two categories of the evidence, then the best shall be given. You shall not withhold the best evidence from the court. And if best is not available, then available best is the rule. Therefore, the third rule provides that you should give the best evidence. If best is not available, then available best should be given and tendered in evidence before the court is the consequence. Then comes the next aspect thereof. The next aspect is what system of jurisprudence is applicable in India as per Indian Evidence Act of 1872. What sort of system we follow in India? And the system which we follow, friends, in India, whether it is inquisitorial system or adversary system of law, you must be knowing, and you must know what is inquisitory system and what is adversary system. Indian law provides for adversary system. We do not follow inquisitorial system. In some of the countries, the law provides, Indian Evidence Act provides, the criminal law provides as to inquisitorial system, while the Indian system provides for adversary system of law. Let us, but I will explain in one sentence what is inquisitorial system and what is adversary system of criminal jurisprudence. As per the Indian Evidence Act, we follow adversary system. Inquisitory system, which is followed in some of the countries, provides wherein magistrate or the criminal judge who is presiding over, he himself is part of the investigation. Try to understand. In those countries wherein inquisitorial system is allowed, in those systems, what happens? Am I audible to you? Am I audible? Somebody is saying that no voice is coming.
Yes, sir. Yes, sir. No problem.
No problem.
Okay. So inquisitorial system provides that in case of inquisitorial system, the umpire, that is the magistrate, he himself is part of the system of investigation. In investigation system, he provides for that leadership, or he's the head of the system. So he's the judge as well as head of the investigation. This is inquisitorial. Impartiality to some extent is lost. However, in India, we follow a different pattern. As per the Indian Evidence Act of 1872, we follow adversary system of criminal jurisprudence. And this adversary system, it provides for, in the first instance, our magistrate, which you are going to become, is umpire. He is impartial. He is not part of the investigation system. This is the beauty of our law. Then we come to the next consequence, presumption of innocence. At the outset, we shall proceed on the basis of what is to be proved, against to be proved, when is to be convicted, etc. And this is with reference to that our system is based on presumption of innocence. Our doctrine of mens rea and presumption of innocence means that unless it is proved, he shall be presumed to be innocent. This is based on a larger principle, which was earlier followed in Western jurisprudence, especially English jurisprudence. Let 100 criminals go scot-free than to punish a single innocent person. Based on that, this is required. So our system is based on the principle that mens rea and especially presumption of innocence. However, nowadays we have understood this mens rea doctrine is excluded while drafting of the laws and making of the laws. In many laws, now this mens rea doctrine stands excluded. Presumption of innocence comes to an end, especially like offenses in the nature of food adulteration, drug adulteration, etc. And then last aspect of this today's law, that is nature, we'll discuss before we understand the further aspect. And the last aspect is what is the standard of proof we require in respect of the civil proceedings and criminal proceedings. Whether the same standard is required in criminal law and in civil law or not. And you know that in respect of the criminal jurisprudence, it is presumed that his guilt shall be proved beyond doubt. However, in respect of the civil law, there is simply preponderance of the probability. Therefore, this is the basic distinction between the two laws, especially as to the standard of proof required in civil law and in the criminal law. Then, friends, we come to the next aspect. Next aspect to be understood here is in respect of evidence is to be given. Evidence is given either by witnesses or by through the help of the documents. As we know, as per the definition, we'll come to that part, all statements and all documents. But before we come to that definition, before that definition is to be understood, let us see what is the place of witness in respect of a given system, or what is the place of witness in respect of the trial before the civil court as well as the criminal court. And this has been explained by Juris Bentham. Juris Bentham, friends, he provides that witnesses are the eyes and ears of the courts of justice. See how succinctly, how nicely Juris Bentham has put in one sentence the role of the witnesses before the courts. They are eyes and they are ears of the courts of justice. Through them, the court will see. Through them, the court will hear and will do the justice. Then is the issue to be discussed at the outset. That issue to be discussed at the outset relates to reasonable doubt. We always say in criminal trials, those criminal lawyers must be knowing that we say that guilt is to be established beyond doubt. What is reasonable doubt? Beyond reasonable doubt. Is reasonable doubt imaginary? Is trivial or merely a doubt in the mind of the judge? Friends, no. It is a fair doubt based on reason and common sense of the judge. It must grow out of the evidence before the court and not out of the mind of the judge. To become a judge, you keep it in mind that it is not growing out of your mind, but out of the evidence before you. And there must be reason and common sense to be applied by you in judging that evidence or assessing that evidence or appreciating that evidence. Then another principle comes as to this proof aspect in this Evidence Act, and that relates to corpus delicti. You must be knowing this corpus delicti doctrine of Latin, but I'll explain in two sentences. Corpus delicti means dead body, body which is part of the offense. Issue is whether to punish a person, presence of the dead body is necessary or not, or whether we want proof of that class, bring the dead body and then convict a person. And this entire law has been explained by the Supreme Court in the very celebrated case of state of Maharashtra versus Tulsiram Bhanudas Kamble, reported in AIR 2007 Supreme Court, page number 3042. In this case, it has been explained by the Supreme Court regarding the importance of or the relevance of corpus delicti, means presence of the dead body to punish a person, and has been held by the Supreme Court in very simple language. Court said that it is word of caution and a rule of law. Rule of law says that to punish a person, presence of dead body is not necessary, but word of caution is given to the judges. Something is said to their mind and something is said to their heart. And the law says here, look, as a rule of law, there is no need of presence of or existence of dead body before the court or dead body. However, there is word of caution given to them. Think twice before punishing a person, that at least dead body is ascertained and is found. That is the consequence as a judgment of the Supreme Court in the case of Tulsiram Kamble's case. And then comes the next principle to be applied. Last principle in the first concluding introduction to the subject. And that is in respect of a Latin principle. There is a Latin principle that is falsus in uno, falsus in omnibus. I'll repeat, falsus in uno, falsus in omnibus. There is a philosophy developed in Latin language, especially in England thereafter, that false in one thing, false in everything. So they followed a principle there in past. Falsus in uno, falsus in omnibus. Falsus in uno, falsus in omnibus simply means if in the witness's testimony of 10 things, he tells 1 or 2 things false, then disbelieve him totally because he is telling some false things and some true things. That is falsus in uno, falsus in omnibus. False in one thing, then presume that it is false in everything. Whether this principle of falsus in uno is applied in Indian Evidence Act and Indian law or not. And friends, you'll find this principle has not been followed in Indian law, and in Indian law, this principle has no place in criminal jurisprudence in India. Then based on this, friends, we'll come to the next aspect. This we have discussed so far only from the outset. We have not entered into the subject. We have not entered into electronic evidence, nor we have entered into the subject of Indian Evidence Act. This you should know as a student of law, and when facing that interview panel for the judicial magistrate's examination as to this nature of the examination. If examiner asks you what is the meaning of the term adjective, what is meaning of the term substantive, then you must be in a position to know. You must be in a position to explain the inquisitorial system and the adversary system of evidence. Based on this, now we'll proceed to the law itself, the contents of the today's act. Friends, I will explain to you that to whom the blackboard is available, and to them there is no blackboard available, take a plain paper and first draw a spectrum of the act. You cultivate, you imbibe in yourself, you inculcate in yourself such an habit. What habit? That have a spectrum. Draw a diagram from section 1 to section 167, especially for today's subject.
सर एक 2 मिनिट आवाज येणं झालं बघतो. व्हेरी गुड.
अर्धा नंबर कुठे दिला?
सर तुमचा आवाज येत नाहीये.
रमेश नंबर दिला
सर. एक 2 मिनिट थांबायचं आहे. नेटवर्कचा इश्यू आहे त्यांच्याकडून काहीतरी, आवड सरांकडून. 2 मिनिटात चालू करू आपण. एक 2 मिनिटात चालू करू आपण. सर चालू करायचं, तुमचा आवाज येत नव्हता आता. सर आपलं हां ओके.
Am I audible to you?
येस सर. येस सर.
yes,
आता येते.
आता येते.
मध्ये गेलं होतं एक 2-3 मिनिट. आता येते.
Amit ji, I am audible to you?
हा यस सर.
येस सर येते.
यस येते.
Amit ji, आवाज येतोय?
येतोय आवाज येतोय.
May I begin again?
हा स्टार्ट करा सर.
I will resume. Thank you.
हा आवाज ऐकू.
Yeah. So you have to prepare first the entire spectrum of the law itself, the sections and arrangement of the sections. As a student of law, and especially for preparing for judges examination, you should cultivate, you should imbibe in yourself such habit so as to discuss entire law together, not in provisions in isolation or separately. How to study law in compact provisions? First is very simple. You draw such a diagram, section 1 to section 167, and put in between various chapters and various elements. Then you will find how this entire law has been interwoven and put together. This entire law is a continuity of the provisions. There are no separate islands in this Indian Evidence Act. There is a continuity of the provisions. And therefore, just today's subject, I will say, you divide today's subject from section 1 to section 167. So, friends, we know what first chapter is, section 1 to 4, comprising of preamble, the application, the act, operation, etc. Definitions. Then in section 5, what is provided? Section 5 to section 55 will deal with the relevancy of facts. Then, especially in section 56 to section 100, section 77, we provide for facts to be proved, which did not be proved, etc. And then, thirdly, we provide for documents and presumptions as to document, exclusion of oral document by evidence of oral evidence by documentary evidence, etc. Then comes the next chapter, which is relating to burden of proof provided in section 101 to section 114. Then comes estoppel doctrine as provided in section 115, 16, and 17. And then comes the next chapter as to witnesses as provided, especially in sections 118 to section 134. And then comes examination of witnesses as provided in section 135 to section 166. And comes the last provision that is in respect of the 167 section as to improper provisions in the Act. This is especially in respect of classification of the provisions. This is at the outset. Somebody has posted a comment that, sir, be little slow. I'll be little slow, friends. This I cover, which was rather out of my syllabus. But nevertheless, as a student of law, till I am a student of law, everybody is a student of law. I just wish to have this background of this law for your information. Now I will go to the proper subject through proper sections. So as to understand, friends, today's subject, we have to understand various notions, especially as to what is fact. You'll ask me a question, sir, we have already seen what is fact. We have passed LLB and we are preparing for this examination. Nevertheless, friends, every time you reread the provisions, you will have different color of the provisions. My teacher used to tell me that today's subject, Indian Evidence Act, is Bhagavad Gita of the lawyers. See that as whenever Arjuna was in doubt, Lord Sri Krishna guided him. Those were the preachings through Bhagavad Gita. Likewise, whenever we the lawyers are in doubt, Indian Evidence Act gives us torch of wisdom. And that torch of wisdom, we understand each time differently. There are different shades of this subject. There are different shades of words used in this subject. Find, friends, that even after about 125 years of its application, there is no much amendments effected in this today's subject. It is because of the work undertaken, the hard work undertaken by the draftsmen at that time. And especially now we come to various aspects in respect of fact. Every now and then you have discussed, but I put a very simple question to you. As now we are discussing here, online, webinar type, you are at your home or in your office, then I'll ask a question, whether in your office there is fact or fact in issue. You just recollect yourself. You try to answer the question accordingly, whether in your office there is fact or there is fact in issue or both present. And to understand this issue, we'll say that it is said every fact in issue is a fact, but every fact is not a fact in issue. Every fact in issue is a fact, but every fact is not fact in issue. For a very simple reason, as to the definition of the term fact given. What is definition of the term fact? I'll be very brief because this is very elementary, but nevertheless, this needs our introduction to the main subject. What is fact? Fact means and includes anything, state of thing, or a relation of thing which can be perceived by the senses. So it is anything, state of thing, or a relation of things. So there is a table is a fact. There is a glass on the table is another fact. There is water in the glass is another fact. But in respect of this, is there fact and issue at present before you and me? This is not, because let us go to the next definition. The next definition is given as to fact and issue. What fact and issue means? Fact and issue means and includes any fact either in itself or in relation of other fact, and what it does, existence, non-existence, nature or extent of any right, liability or disability is done what? Is asserted or is denied, where in any suit or proceedings. So fact and issue is where? In the court. Fact is where? Here in the office. Therefore, fact is different thing and fact in issue is different thing. So as to have facts in issue, there must be what? The last word in the definition of fact in issue. What is the last word in the definition of fact in issue? The last word in the definition of fact in issue is that in any suit or proceeding which necessarily follows. So as to have any fact in issue, there must be suit or proceedings. So fact becomes fact in issue if it is of that category of the fact in such suit or proceedings. This is the correlationship between fact and fact in issue. But here, let us see the consequence. What is the fact? What is the nature of the definition? Do we find that, say, offense of murder is defined in Indian Penal Code? Is it like means and includes? If you find definition of proposal in Indian Contract Act, do you find that proposal means and includes? Why in the definition of fact and fact in issue, the words are said to be means and includes? See the difference. Sometimes definitions are precise. In the definition, what is stated is precisely like murder, like culpable homicide. So those offenses are clearly defined. Nowhere comes means and includes. In Indian Contract Act, as to proposal and acceptance, nowhere comes as to means and includes. Why? In the Indian Evidence Act, as to fact and fact in issue, the word means and includes has been used. We have to understand why it has been used. Whenever the term means and whenever the term includes, there are two aspects. Means provides to descriptive aspect, while includes relates to illustrative aspect. So in this definition, in this act, the Parliament has intentionally used the words means and includes. So it means it is described. When it includes, they are illustrated. So sometimes facts are comprehensive, sometimes they are illustrative. That is the consequence in respect of definition as to fact and fact in issue. And therefore we have to say every fact in issue is a fact, but every fact is not a fact in issue unless those qualifications, those requirements are fulfilled, and especially there is any suit or proceeding pending in the courts. If there is no suit or proceeding, there is no fact in issue. We'll discuss at a later stage issue in respect of issues of fact and facts in issues. Then come the consequence in respect of proved and disproved and not proved. I'll take only one sentence aspect. You have been already taught is the consequence hearing. Issue is in respect of proved. What is proved? After considering the matters before it, the court believes that such fact exists or considers its existence so probable that ordinary prudent man shall act on the supposition that it exists. See how beautifully this provision has been drafted by the British draftsman. That has been said here that proved means after considering the matters before it, the court either believes that it exists or believes its existence so probable that the ordinary prudent man shall proceed to believe that it exists. So there is preponderance of the probability brought into. What is disproved? When the court, after considering the matter before it, considers that so it does not exist or considers its non-existence so probable that ordinary prudent man shall proceed to presume that it does not exist. What is disproved? We have seen. What is not proved? When any fact is neither proved nor disproved, then that is open for both of them to prove. And then based on this, we have to come to the next consequence in this behalf as to evidence. But before we go to the evidence, sometimes in your examination, two types of query may be raised. Had I been the judge, especially in oral interview of yours, I would have loved to ask such a question to you. What question I would have loved to ask to you people, that what is fact in issue and what are issues of fact? Explain, please explain what are facts in issue and issues of fact. And this issue is to be understood, especially provisions in the Civil Procedure Code, especially in Order 14, Rule 1. Order 14, Rule 1 of CPC provides for what? Framing of issues in the court. Whenever, as we know in civil trials especially, the plaintiff is instituted, suit is instituted, then there is written statement, and the further documents are filed along with Exhibit 3, and then comes the issue, then comes the case of framing of the issues. So as to provide the scope of the Evidence Act, so as to provide what sort of evidence is permissible in this case, the judge, with the help of the lawyers, decides for framing of the issues. That provides for scope of the civil trial especially, or points in the criminal cases. That is the consequence. So, and what is fact in issue? That is the theoretical part. What are issues of fact is a practical part. Therefore, the facts in issue, that is in Evidence Act, while issues of fact, they are to be found especially in the Civil Procedure Code. This is the consequence to be found in respect of these provisions. Based on this, we'll come to the next aspect, friends. Next aspect is to be found especially in respect of evidence. What is evidence? See, I'm taking you from a very small thing which you have learned your LLB course to the higher things now. From nature, from classification, from definitions, we are coming to the next part as to evidence, which is one earlier step of electronic evidence. What is evidence? Evidence means and includes again. There is no precise definition of the word evidence in this Indian Evidence Act. Especially you will find the word evidence has been defined to mean and to include something. Therefore, it is descriptive as well. It is inclusive or illustrative. It is exhaustive definition. Nothing is left out of it. Therefore, Indian Evidence Act, then drafted about 125 years back, is suitable today also for this very reason. What reason? That it means and it includes. What it means and it includes: A, all statement which court permits or requires to be made by witnesses before it in relation to matter under inquiry before it. So all statements made by witnesses are required by witnesses to be made before the court. All statements, oral evidence. The B part, second part provides for all documents. We'll go to definition before 2.0 first, and then we'll go to definition after 2.0. Because on 17th October 2.0, there is amendment introduced in this act. So before that amendment introduced by the Information Technology Act of 2.0, let us try to understand the second part of the definition. Second part of the definition relates to all documents, including all documents produced for the inspection of the court. Such documents are called as documentary evidence. What is the amendment effected? Word electronic record has been added. All documents, including electronic records, produced for the inspection of the court, hereinafter called as documentary evidence. So, the word document is now qualified, or there is something added in the definition. Previously, we had that concept of the evidence as per section 3. Now that has been widened, and now electronic record is also included in the definition of the document. What is document? There is also defined in this. You have discussed that document aspect. Nevertheless, just to refresh our memory and to maintain the continuity without you referring to the books, let us see what is document. What is document is any matter express or describe upon any substance with the help of letters, figures, or marks, or any of such means for the purpose of recording of that matter. So This is the aspect in respect of definition of the term document and the term evidence. And now, in furtherance of this, we have to come to the next consequence, that we are going to electronic evidence now. We have seen document, we have seen evidence. Whether the term electronic evidence, friends, have been used anywhere in the Evidence Act, and that is our today's subject. And therefore, I will say that even though with Amit sir's consent, we have taken today's subject to be electronic evidence, friends, nevertheless, there is nothing like electronic evidence. There is nothing like electronic evidence, because in respect of electronic evidence, there is no such word, there is no such definition provided in this act. Then what is it provided? Electronic evidence is a term which is derived from the Information Technology Act and the amendment in the Evidence Act. Therefore, there is the term electronic record and not electronic evidence. The term electronic record itself is construed to be electronic evidence. That is to be proved. Therefore, that is a fact. So as to understand this, let us come to the next part of the provisions of our today's discussion. And that next part of the today's discussion relates to proof of facts. How facts are to be proved. Unless we generally understand how facts are to be proved, friends, how we can understand proving of the electronic record or the electronic evidence? And to understand proof of the electronic record or proof of the electronic evidence, let us first see how we normally prove facts in the courts as per the evidence law. And you know this, that there are three aspects of it. What three aspects? Facts which need not be proved, and secondly, proof of facts. The facts which need not be proved, we have already understood it. You have learnt it, but I will just have the few glimpses of the aspect and the niceties thereof. Especially we will find that these provisions are to be found in section 56, section 57, and section 58. What are the consequences? That court will take a judicial notice. Nothing is to be proved. Or court must take a judicial notice, like laws and acts, offices and advocates and attorneys, etc. And thirdly, facts admitted need not be proved under section 58. And here is a danger for the aspirants of the judges examination. Had I been a judge and it is an oral interview going on, I would have loved to ask such a question to you, friends, regarding section 58. There are such hidden provisions in Indian Evidence Act which are prone for your first examination, your second examination, and third examination. Such provisions are having that beauty that such sections are to be asked at these three examinations. Likewise, section 58 may be relevant for oral examination. But section 58 provides facts admitted need not be proved. Is it eternal truth? We are always thinking that this is a final truth. This is a half truth. Facts admitted need not be proved. It is a half truth because there is a discretion given to the court. And how facts may be admitted? How facts are admitted? Even go to the provisions of CPC. You go to the provisions of the civil manual, and you will find there are two methods of admitting the facts before the court. How the facts are admitted in our civil court procedure, especially at the hearing, they are admitted. If hearing is going on, then they are admitted at that time in writing. And secondly, before hearing, such party agrees in writing to admit the facts of the case. Thirdly, there is a provision made. There is a provision, especially in this behalf, court may, in its discretion, may require such a fact otherwise than admission. You know that effect of admission and confessions later on. But here, at this juncture, let us see the beauty of the provision. You just have the introspection. You look into yourself and ask a question that facts admitted need not be proved is not absolute truth. There is a discretion given to the court, and the judge may require any fact, even though admitted, to be proved otherwise than admission. So this is the discretion given to the judge in such a case. Then, friends, we'll go to another provision, that is with reference to what is the standard of proof or proof of facts to be given. And especially These provisions are to be found in sections 59 and section 60 of this act. Section 59 and section 60 of this act relate to oral evidence. What section 59 says, all facts except the contents of the document shall be proved by the documentary evidence. All facts except the contents of the document may be proved by oral evidence, except contents of the document. And what section 60 provides? Oral evidence must be direct and not hearsay. We'll discuss why it is not hearsay evidence is permitted in the courts. Nevertheless, these two provisions are providing for the elementary consequence, because this distinction between section 59 and section 60 ultimately led to the consequence in the portals of the Supreme Court. Because of that, this was misconstrued by the judges of the Supreme Court, and therefore the larger bench was required based on section 59 and section 60. We'll discuss the relevance of this section at that time. But section 59 says that all facts except the contents of the document may be proved by oral evidence. And section 60 says oral evidence must be direct and not hearsay. That is the consequence provided in respect of that provision. While especially section 61, section 62, section 63, section 64, and section 65, they relate to the provisions in respect of facts and facts to be proved in this behalf. Based on this, let us go to that aspect now, which we have left unturned just 1 minute before. Proof of oral evidence. This was in one of the cases before the Supreme Court in respect of electronic evidence. So let us see, unless this section is understood, we cannot understand that case and the consequence before the Supreme Court. Especially as per section 59, all facts except the contents of the document may be proved, or all facts except the contents of the document and electronic record may be proved by oral evidence. Oral evidence must be direct and not to hearsay. What is hearsay? What is direct? What is hearsay? So direct means who has seen it. Direct means who has heard it. Direct means who has perceived it. And direct means who is holding that opinion. That is direct. What is indirect? Indirect means somebody has seen it and he has told me and I am going as a witness. So who has seen, who has heard, who has perceived, who is holding that opinion, his opinion is said to be the direct oral evidence. And on that somebody's opinion, if third person is holding his opinion, then that becomes indirect evidence. That is not permitted. That is said to be hearsay. And why not permitted? What was wrong with this? Friends, let us not only read the law. Friends, let us not only have the letters of the law. Let us see the philosophy behind it. What is the philosophy? Why the legislators might have compelled to enact section 60 in such a way? What would have been wrong if it was permitted that the direct as well as indirect and even hearsay evidence is permitted? What would have been wrong? And the wrong would have been committed here, friends, if it is permitted that somebody has seen murder, so his testimony is relevant. But that someone has told it to me, and then I say that my friend has seen the murder, and I depose in the court. Court says it is hearsay, not admissible. Why not? What is wrong? Why such a general rule is made whereby that is made inadmissible? And that is so made inadmissible for a very simple reason, that because testimony and adducing the evidence before the court, especially the witnesses coming before the court, what is required? Oath. What is required? Cross-examination. And what is required is his demeanor. Means his behavior before the court. So three things are very necessary. Very intelligent lawyer, especially criminal practitioners, they provide for this. But criminal practitioners, they are well versed as to cross-examination and the demeanor of the witness before the court. That is very relevant in this case. And what happens in respect of hearsay evidence? That person who has seen is not coming before the court. And therefore, there is no oath. Therefore, there is no cross-examination, and therefore there is no demeanor of that person to be analyzed by the court, and therefore it becomes of less probative value. Therefore, that is not to be easily relied upon. Based on this, we come to the next consequence. First, we have seen how oral evidence, what oral evidence, and then we come to the next concluding part of this first part of the discussion of today. That is documentary evidence. Hereafter we'll go to the electronic evidence. So documentary evidence. So in respect of documentary evidence, I'll be very brief just to refresh your memory of this part of the Evidence Act. Section 61 to section 65 provide for these consequences. What section 61 provides? The contents of the document or electronic record may be proved by primary or secondary evidence. So it is a general statement. There is nothing stated. What it says, contents of a document or electronic record may be proved by primary or secondary evidence. So there is a general statement. What section 62 is provided for, that is very material. And that provides for document itself produced for the inspection of the court. When document is produced for the inspection of the court, then that is the consequence. Friends, this simple aspect as provided in section 61 and 62 was in great controversy in case of Anwar PV's case, which has been ultimately to some extent corrected in case of Kailas Gorental and Arjun Khudkar's case. This simple word sometimes leads to the great controversy in the apex court in the Supreme Court. What controversy? The contents of document or electronic record may be proved by primary or secondary evidence. And primary evidence means document itself produced for the inspection of the court. Issue arose in Anwar P's case. We'll discuss at proper time. And as well as in Arjun Khudkar versus Kailas Gorental's case, the issue was rotating about this primary evidence and secondary evidence. Whether section 65B certificate is required or not was the question before the Supreme Court in number of cases. That arena of cases we'll discuss at the end. But you will find here, while construing those provisions, the misconception was in the minds of the judges as to the word primary and secondary. And therefore, the case of Anwar PV has been corrected by the Supreme Court. Therefrom, this section was made relevant in the subsequent larger bench, that is the full bench of the Supreme Court. So you have to read this definition properly. And then we come across explanation is appended below section 62 that what is a document means if it is executed in several parts, each part is original, that is primary evidence. Then it comes to it is a counterpart, every part is primary evidence. Then there is uniform process provided for making of the documents, then it is primary evidence. Or there is a common original, then that is said to be the primary evidence. We'll not go into those details. Then comes secondary evidence, because for section 65B of the Indian Evidence Act, read with Information Technology Act, that is relevant here. What is secondary evidence? And that is provided in section 63 and section 64 and section 65. What is secondary evidence, and when that becomes admissible in evidence is discussed in those provisions. And especially to understand what is secondary evidence, we have seen certified copies, copies from original, copies made and compared, counterparts of the documents, and the oral account of the contents of the document, who has seen it. It is said that it must be proved by primary evidence except the cases hereinafter. Let us see relationship between section 63, section 64, and section 65. What is section 64? That is the bridging the gap between the two sections. Section 63 defines secondary evidence. Section 65 provides when secondary evidence is admissible. And what section 64 provides? It says that every document must be proved by primary evidence except the cases hereinafter stated. So section 65 is an exception to that. What is general rule? Primary evidence is a general rule, friends, while secondary evidence is an exception. Why? If at all your examiner asks you such a question, that explain. Primary evidence is a general rule, while secondary evidence is an exception. Why? Where is the answer given in your book? And there is nowhere answer given. It is impliedly given. And where it is impliedly given? In section 64. What section 64 says? Section 64 says that documents must be proved by primary evidence except the cases hereinafter provided. Means under section 65. Means all those evidence or those documents as per section 64 shall be proved by primary evidence and not by the secondary evidence. We know that Secondary evidence is admissible in those cases wherein original is lost, original cannot be moved, original is in the custody of the other party, certified copies are permissible, etc. Based on this, friends, we have to come to the next part. We have seen one by one. Let us come to the important part, that is heart of today's discussion. The heart of today's discussion is as to electronic record. What is electronic evidence? At later stage we have said, earlier we have said that there is no such word called as electronic evidence. There is a word called as electronic record. And that word electronic record means electronic evidence. There is no such term as electronic evidence defined at anywhere. So let us see what is this electronic record. So friends, the term electronic record has been used in section 2 small t of the Act, that is the provisions in this behalf. It means electronic record means data recorded or data generated or image or sound stored, received or sent in on electronic form or microfilm or computer generated microfiche. This is what is electronic record. In this definition, what is used? The word data has been used. What is data? Every now and then, even a small boy says that my data is now over. Mobile data is over. What is data? What is data means, as per section 2.0 of that Act, data means a representation of information, knowledge or facts, the concepts or innovations which are being prepared or they have been prepared or formalized in a manner intended to be processed or being processed in a form including computer, printouts and internal memory of the computer. So here are certain technical words used. We'll do away with the technicalities and we'll come to the consequence thereof. What is the consequence thereof? Today, what type of electronic evidence, electronic record or such a data we come across? Computer generated documents, recorded tapes or the recorded calls or newspaper reports or audio and CDs or video conferencing, DNA test, brain mapping test, CCTV footage and photographs to be done. These are email, WhatsApp messages, Instagram messages, etc. How they are to be proved, that is the next part of the discussion. In respect of proof of such facts and proving of such facts or the relevancy of such facts is provided especially in section 65A and section 65B of this Act. This is amendment of 20. Came into force when? 17th October. From 17th October, law has been changed to incorporate within its embargo or province the concept of electronic record as a document. But it is not necessarily that from that amendment of 2000, this law has been added and we are considering its need in interpretation of law and the evidence to be recorded before the court. The Supreme Court long before has laid down a law in the year 1974. So friends, to understand the concept of electronic evidence in detail may not be from examination point of view, but for your personal satisfaction and your love for the knowledge, it is necessary that we have to today learn a span from 1974 to the year 2020. That is the first case which was decided by the Supreme Court in this case was Som Prakash versus State of Delhi, and the last case, the recent case which we have to understand is the case of Arjun Khudkar versus Kailas Gorenthal. This is the span. This span we have to study with the help of cases hereafter. So first case which we understand is in respect of Soma Prakash versus State of Delhi, reported in AIR 1974 Supreme Court, page number 989. In this case of Som Prakash versus State of Delhi, the Supreme Court has highlighted the need for the adaptability of the new methods as to recording of the evidence, new technology. This has been emphasized by the Supreme Court. I'll read the words of the Supreme Court. I'll borrow it from my note. Supreme Court has said that in our technological age, nothing more primitive can be conceived of than denying the discoveries, and nothing cruder can be the retarding of forensic efficiency that severing the traditional oral evidence, only thereby discriminating the liberal use of scientific aids to the proof. The Supreme Court then, in the year 1974, has highlighted that this technological development we have to consider while interpreting the Indian Evidence Act. And see the beauty of the act so articulately drafted in the year 1872. Even after such an amendment, the law stands the test of the time. Law stands the test of the time in a simple way that even in the given situation, even after about 125 years, the provisions are still holding good under the changed scenario, and application of the law is the consequence in respect of the drafting of this law. So after the case of Som Prakash versus State of Delhi, the next consequence was regarding the provisions in this behalf. What we have decided to discuss now, as to tape records, as to photographs, as to emails, etc. Let us see each one of them. Let us see each one of them in little more details. Let us see how tape record can be proved. Every now and then, your version or our conversation is subjected to taping. Or rather, friends, I will tell you that, look, big boss is always watching. You are saying that I am free today, I'm talking to something, and I send message on WhatsApp to my someone else, and there is a heading that the messages on this from start to end are encrypted. Means they are said, nobody can intercept. So apparent, I'll cover CCTV also. So apparently what happens when we read that message phone book and message book, then what happens? Then what happens is, in that WhatsApp messages, what is the heading? You look into that messages, they are encrypted. No interception is allowed. Nobody can see your and my messages. But friends, case is otherwise. This ghost in the form of mobile, this media has exposed to ourselves. Very recently, you must have read that mobile data of crores of people that has been hijacked and sold in the market. What has been sold? Say, friends, I have got a habit. When I'm in journey, I always put on my mobile and I put anybody's lecture, and then I have my earphone, and for the journey I'm listening. As Alange sir has said, I have moved throughout Maharashtra for this purpose. And then in the journey, I learn many lectures. When I come home, and I put on search on the YouTube, you'll find only lectures and lectures are coming up. If somebody hears bhajans and kirtans, like Baba Maharaj and other Maharaj on this, then you'll find that they are sending on your mobile only those in the first criteria. Likewise, friends, if you're seeing something, mind well that somebody is watching, and that can never be erased. In the prime server, wherein from this entire system is rotating, everything is stored there. Nothing is erased. Even though you may delete from your mobile, you may delete from your own instrument, nevertheless, that is not and never totally erased. That is preserved somewhere. And when required, court may call for, or somebody may call for. So be aware as to use of this instrument. That is usually everything is preserved in this behalf. Let us come to tapes. It's very easy nowadays. How it can be subjected to as a good evidence in the courts. How it can be electronic evidence in the court. Say, for instance, your mobile is very easy not to catch anybody. And say in your mobile, you come to visit somebody and put in your pocket and put it on. Everything is recorded. Whether this tape recording is evidence, or say like a tape recorder is brought and it is recorded, whether this can be subjected to evidence in the courts or not. And we have to understand the issue with reference to this aspect of records, tape records, and its admissibility, authenticity in the courts. So as to understand the tape records and its authenticity in the court, we have to have reference to a very celebrated case of the Supreme Court. The name of the case is Ziauddin Bakhruddin Bukhari versus Brij Mohan Ramdas Mehra and others. Ziauddin Bakhruddin Bukhari versus Brij Mohan Ramdas Mehra and others. Reported in AIR 1975 Supreme Court, page number 1788. This is the case wherein the court itself provided for, Supreme Court itself provided for framing of the law. Generally, we say Supreme Court never makes the law. Supreme Court simply declares the law, except constitutional judicial activism. Supreme Court never makes a law. Supreme Court simply declares the existing law. While here is exception to. This Bukhari's case is exception to that law. This is not judicial activism too, but there is a different procedure followed with reference to the Constitution, you must understand. In this case, issue was before the Supreme Court whether tape recorded version is a document within the meaning of this act or not. Whether, as per section 3, the definition, as per section 3, definition of the term evidence and document has been provided, whether tape recorded conversion, a tape record is within the meaning of that document or not, was the question before the Supreme Court in Bukhari's case. An issue was how such recording, re-recording, hearing, and evidentiary value is to be judged, was the question before the Supreme Court. And in this case, what happened? The Supreme Court, then, there were stray instances, there were stray rules in respect of proving of the tape recorded conversion or tape recorded version. In this case now, the Chief Justice of the Supreme Court and other companion judges of the Supreme Court, they sat together and then they drafted rules in this behalf. They drafted rules in this behalf, and rules so drafted, they were sent to the governor for the approval under Article 227 of the Constitution. Under Article 227 of the Constitution, those rules were sent to the governor for approval. It's very extraneous procedure. It's a very exceptional procedure. Usually, who sends to the governor? The chief minister or the state legislature. Now here, the Chief Justice, companion judges, they frame the rules and send to the governor under Article 227 of the Constitution. And those rules, they have been allowed, or rather, there was confirmation from the governor, and then such rules have been made. It is said till there is a law in this behalf, these rules shall be followed in the courts for proving of tape records. So let us see what are the rules then. Such rules, they have come into practice and they have been in force since 1/8/1978. So first, whenever you want to prove tape recorded conversion, what you have to do? Simply taking the tape or your mobile and giving the code is not sufficient. It may be sufficient for other kinds of electronic evidence. But if it is a tape recorded conversion to be proved before the court, then we have to follow a different procedure. And what is a different procedure we have to follow? First, there is a transcript. What is the meaning of the term transcript? Transcript means it's typed version. So what is said is to be typed, and that is said to be a transcript. And then that tape and the transcript both, you have to give to the authorized officer of the court as per the court orders. And it is in safe custody that is put. It is in safe custody that is put, that is sealed. And whenever it is open with the orders of the court by the authorized officer, then thereafter again there is a resealing of the consequence. Then if at all there is a notice of production given through the court, then there can be application to be made for hearing of the instrument. If other party intends to hear it, then he can give notice to the court, and then court will order that this is to be allowed, rehearing is to be allowed. But there is a very strict procedure. It shall not be tampered. Nobody shall interfere in the tape recorded conversion. And therefore, the court has very intelligently drafted the rules and has said that this is to be run only on 2 or 3 occasions. Otherwise, what will happen? Otherwise, it is very likely that its originality, its authenticity, its effectiveness may be affected. And therefore, for 2 or 3 occasions you can run. and then every time that is to be in the audience of the authorized officer. It is not that you are hearing alone, therefore there can be tampering in the tape. So it is in the presence of the authorized officer of the court. Then only this is permissible with reference to Bukhari versus Brij Mohan's case. And then it is to be, there is a separate exhibit. In case what you usually find that something is given in the court, that is exhibited, as we know, as per the provisions of the Evidence Act. Here, there are two exhibits are given. One is to the instrument and second is to the transcript. That is also provided for the transcription. If it is in Marathi, tape record is in Marathi or in any regional language or in Hindi language, then that language version is to be given as well. English version is also to be given. Especially you will find the criminal manual of Bombay High Court in Rule 24 thereof provides for details about this. Rule 24 in criminal manual provides for this consequence as to tape records and the consequences thereof. This is a detailed consequence in detail with reference to tape recorded conversion. Then friends, we come to the next consequence. Next consequence is that we'll consider, somebody is saying that explain CCTV footage also, I'll explain. And I request Amit ji to extend my time little further. So narco-analysis test, consequences in respect of narco-analysis test, whether it is relevant or not. Sometimes we find that narco-analysis tests are to be administered, whether that is subjected to this consequence or not. Even our Pune's ex-commissioner of police, he was subjected to such examinations, whether this is permissible or not. And in this behalf, let us see, the Evidence Act is silent on the topic. Indian Evidence Act, there is no iota of provision regarding narco-analysis. However, this term has been used for the first time in the history in the year 1936. The first application in India was done in the year 2001. This concept as to narco-analysis test was done especially at Bangalore in Forensic Science Laboratory at Bangalore in the year 2001, wherein one of the associate of Virappan was to be examined, and in respect of him, the narco-analysis test was to be carried on. However, today there are guidelines given by the National Human Rights Commission of India, and it is said that unless the person consents for the same, there shall be no narco-analysis test administered against his wishes or without his consent. Report of the consent is to be seen, report of the expert is to be seen in this behalf. You know, in Tilgi stamps scam, this was used. Then in ROC murder case was done. Use in this case, I have one scientific term for your information only. The use of sodium pentothal or sodium amytal is used. However, it is found that this test, if it is administered without your consent, that therein there is violation of the fundamental rights. If it is administered against your wishes, especially we know the case how self-incrimination is not allowed under Article 2022, and when self-incrimination amounts to violation of fundamental rights, there is a very old case. Which case? Nandini Satpathy versus P.L. Dani, decided by the Supreme Court. Self-incrimination is not permitted. However, as Section 45 of Indian Evidence Act is silent on the forensic evidence, and therefore this issue as to narco-analysis has got very, very limited aspect, and he is said to be subjected to the rules of the National Human Rights Commission. Otherwise, there is violation of the fundamental rights. Then we come to the next aspect, friends, in this behalf. The next aspect as to this issue of examinations relates sometimes to brain mapping tests, also called as P300 cases. P300 cases are especially as to brain mapping cases. There is a issue before the court, and that was in respect of Ramchandra Ram Reddy versus State of Maharashtra. The Bombay High Court then said that this is a legal test. In Selvi's case, it was held otherwise by the Supreme Court. But in this old case, reported in 2004, all Maharashtra criminal 1704, Bombay High Court had hailed that such a test is legally valid. P300 test is legally valid. However, you'll find at a later stage, there was a case decided by the Supreme Court in the year 2010, that was Srimati Selvi versus State of Karnataka, AIR 2010, Supreme Court, page number 1974. And it has been held there that the test has no absolute success rate. The test has no absolute success rate, and that is violation of Article 20 into bracket 3 of the Constitution. This similar issue was before the Supreme Court in the case of Ranjit Singh Sharma versus State of Maharashtra, reported in AIR 2005, Supreme Court, page number 2277. Mr. Ranjit Singh Sharma, he was then the Police Commissioner of Pune City. And in respect of some offences, etc., he was subjected to this issue, wherein issue had been ultimately to the Supreme Court in the year 2005. And this issue has been left open to the Supreme Court, and there is a less probative value of this method of brain mapping or P30 test. The P30 test is subjected to the consequence, and therefore it has got lesser value, and those aspects of the constitutional jurisprudence are to be followed. Otherwise, there is a violation of fundamental right, Article 22 into bracket 3 of the Constitution. Then we come to the next aspect, that is in respect of CDR, compact disc record. In respect of CDR, whether that is admissible in evidence or not. That is electronic evidence, that is electronic record, whether that is admissible in evidence or not. And its admissibility is decided by the Supreme Court in the case of Sonu alias Amar versus State of Haryana, decided in the year 2017, Supreme Court, reporters SC. CDR, whether of a mobile phone, is admissible in evidence or not. In this case, it was exhibited in the trial court, but there was no certificate granted under section 65B into bracket 4, whether raising the issue in the higher court will be permissible or not. See, look here, that certificate is to be issued. Then that becomes admissible. We'll discuss 65B arrangement hereafter. But issue is, Sonu alias Amar, somebody has asked that, repeating the case law, Sonu alias Amar versus State of Haryana, 2017, CJ, SC, page number 649. So, in this case, the consequence was very simple. Certificate was not given, it was not accompanied, case was decided, but in the Supreme Court issue was taken, that certificate was not given. And it was not objected at the trial court for its exhibition, whether that can be admissible or not. And Supreme Court held that such objection must have been raised in the early beginning and not at a later stage. However, in Arjun Khotkar's case, this has been further explained by the Supreme Court. Then comes the next consequence, relevance of video conferencing as the evidence or electronic evidence, its utility rather. Today, it has become a very current position that almost in every courts, video conferencing is going on, especially in family courts, there is video conferencing permitted. In our Pune family court, there is a special room constituted for the purpose of recording of the video conferencing evidence. Issue is that when from this procedure started. And this procedure started from the case of State of Maharashtra versus Dr. Prafulla B. Desai, reported in 2003, volume number 4, SCC, page number 601. In this case, party seeking the evidence by video conferencing. Other party was in the United States of America. Whether this is to be provided or not, whether this is to be allowed or not. And especially the consequence was, objection was, as a nicety was, what was the nicety? The nicety was in respect of section 273 of Criminal Procedure Code, that it should be in the presence of the accused. whether that is satisfied. Technical issue arose. Today it is not a technical issue. It is set traced by the Supreme Court in the case of Praful Desai's case. Issue was very simple, that especially in respect of whether section 273 of CRPC is followed or not, or satisfied or not. And it has been said by the Supreme Court that yes, such video conferencing is good sort of evidence and this is permitted. Rather, this is better than our ordinary witness examined in the court. Why? Because in case of video conferencing, you can hear, you can see, and you can rehear also. So it is like our cricket play and replay of the cricket play. So this is a good sort of evidence in respect of the video conferencing as has been held in this behalf. We go to the next consequence. Next consequence is in respect of email. Every now and then there are emails sent. There are contracts by email. There is proposal by email. There is acceptance by email. We were teaching in courts. In classes. Alange sir, Honorable Alange sir, he was also teaching in classes. My guru, he was also teaching us. What we are teaching? Proposal can be how? Proposal can be in person. Proposal can be in writing. Proposal can be on telephone also. Proposal and acceptance we have discussed then. And there are illustrations given in your Indian Contract Act. Issue is very simple. Whether then it can be proposal on email and there can be acceptance on email. And how it is to be proved then. So it has now been established that proposal can be on email, acceptance can be on email. Now we see that there are such cases of email correspondence. But how to prove? If at all there is proposal on email, acceptance on email, then how it is to be proved? And was the question before the Supreme Court. This entire issue as to proof of email, it was before the Supreme Court in the case of Abdul Rahman Kunji versus State of West Bengal. In respect of Abdul Rahman Kunji versus State of West Bengal, issue was in this case whether such a certificate under section 65B(4) is necessary or not. And it has been said in this case that when such a certificate is obtained, then such a certificate is to be provided along with the email text. How to prove email is very simple. From your mail or email, you can have the text down, its text downloaded. Produce that text in the code along with your certificate. How certificate is to be given and the form of the certificate we'll discuss in course of discussion before we complete. So email is submitted to the court, text is submitted to the court along with the certificate required under section 65B(4). Then what is to be seen here? And then along with this, you have to give IP address of the originator and the receptor. In respect of this email, what is to be provided is IP address of the originator who sends it and the receptor who receives it. That is to be seen provided in this behalf. Issue is further that whether SMS and MMS sent, they are admissible in evidence or not. SMS and MMS sent, whether they are admissible in evidence or not. And it is found here also that SMS and MMS are also admissible as an electronic record and was the case before the Honorable Supreme Court. The case was before the Honorable Supreme Court that firstly, it was the case of State of Delhi, NCT versus Muhammad Afzal in the year 2003. It is said that there the text of the SMS, text of the SMS, text of the MMS along with the certificate, such evidence is admissible before the court. We'll go to the next aspect as to relevance of CCTV or footage. So in respect of CCTV or footage, issue has been explained by the Supreme Court in the case of Jagdev versus State of Delhi that certificate under section 65B(4) is necessary. But this is half truth, friends, because if it is the CCTV and that entire CCTV is given in the custody of the investigating officer, whether certificate is necessary or hard disk from my CCTV is taken and is produced before the court, whether certificate is necessary. Entire case law, and especially Arjun Khotkar's case, rotates about this axis, friends, that if it is secondary evidence, then that is necessary. If electronic evidence is original electronic evidence, then there is no need of any certificate. This you have to keep as a bottom line of our discussion, that only if there is secondary electronic evidence, then certificate. If there is no secondary evidence, but it is a primary evidence, electronic evidence, then there is no need of certificate. So in this case, it is held that if original DVR is found and then that is working, then no certificate is necessary. It has been so said by the Supreme Court in Jagdev Singh's case. Then comes the next consequence in respect of digital photographs. See the beauty of this. What is digital photograph? We take from mobile digitally or other equipments. Then that is stored where? In my mobile. And that is to be produced. Say for instance, murder is taking place, some offense is taking place, and you have taken a shot of that particular thing or a short film of that thing. That whether that photograph is admissible in evidence or not. It is. Then how it is to be proved? Because there are two things, friends. First, admissibility of the evidence and authenticity of the evidence are two things. You have to always keep in mind. Admissibility, that is bring in, and then its contents and its veracity. Authenticity is another thing. First, let us see whether that is in the photograph is in. How that is to be proved and how its authenticity is to be proved. So, if it is the mobile and in my mobile, there is the offense picture I have taken or photograph I have taken, then that is permissible in evidence. How I say that I don't want to go to the court again and again, take my mobile and take it in your custody. I give in the custody of the authorized police officer and then he produces in the court. This is primary or secondary? This is primary. If this is primary, there is no certificate necessary. But if I say to the investigating officer, look, I am an advocate and my phone is given to different clients, I need it. So at the most, you please take down a copy from this and when necessary, I will come in the court. And then if he's copying from my mobile, if he's copying from mobile and is taking that copy to the court, then in that case, that becomes secondary evidence of photograph and then certificate under section 65B4 will be necessary. That is in respect of the consequence regarding digital phones and mobile phones and digital photographs. Then comes the question of hard disks. Sometimes in in computers and various equipments, there is hard disk provided. So there are various aspects provided in the hard disk. Issue is whether that hard disk and its proof in the court, how ensure? Say for instance, income tax come and they seize your document and from your say instrument, they take out hard disk. Or for any offense, it is to be produced in the court. Whether hard disk is primary or secondary evidence. Hard disk is a primary evidence, it is not secondary evidence. But if at all, they are taking only copy out of it and they're taking this copy to the court, then that is said to be secondary evidence. As soon as it becomes secondary evidence, then what happens? If it becomes secondary evidence, as soon as it becomes secondary evidence, certificate under section 65B4 is necessary. Especially, this issue has been highlighted by the Supreme Court in the case of Dharmabir versus Central Bureau of Investigation, wherein this issue as to hard disk has been discussed in detail aspect. Then comes next issue. And that next issue relates to the traditional lawyers like us. We have become like Alangesar lawyer before 45 years. And say in respect of bank extracts, whether in case of bank extract, how they are to be proved. How in past we the lawyers, traditional lawyers used to prove the bank extracts. Bank extracts were given by the bank. How the bank extracts were given, do you know? How we used to prove in the past, do you know? Very simple. Bank could give the bank extract. Then that was duly signed by the bank. There was duly signed and then that was given produced in the court. Then, do you know? how any document is required to be proved. Or say, for instance, sale deed is to be proved before the court. We have to bring the author of the document, not only document, author of the document, his examination, his cross-examination, and so on. So we say that, is it your signature? It is correct. He says, yes, it is my signature, and then document is proved. However, now you get a extract from the bank and there is nowhere signature. You get, say, for instance, you pay for your corona policy, you pay for your mediclaim policy, or say your vehicle policy, and you pay online and they send the document online. What is the footnote? This is electronically generated document and requires no signature. How it is to be proved then? Do you know, we traditional lawyers, we are accustomed, we are known to proving the document with the signature, the contents of the document, and so on. How electronically generated document is to be proved was the question before the Supreme Court in case of State Bank of India versus Rizvi Exports. In case of State Bank of India versus Rizvi Exports, issue was printout of a loan account, how it is to be proved. Printout of a loan account is to be proved. It is a printout. It is said here, certificate from the banker's book account is necessary. If it is not filed, then that will not be admissible in evidence. Therefore, admissibility will be affected thereby. Then we come to the next consequence, and that is in respect of much spoken in between about, I will take 10 minutes more. Alange sir. Sir, I will take 10 minutes more, please. I presume the extension of time.
Yes, sir. Yes, sir.
I will presume extension of time.
Yes, sir. Yes, sir.
Provisions in section 65B are to be understood now. Especially, they are to be understood with reference to section 88A of the Evidence Act. Especially section 65A and its nature is to be understood. It is explained in further cases that how itself is a self-contained code. How it is self-explained code. This self-explained code, self-contained code has been explained by the wording of section 65A, that special provisions relating the evidence of e-record. Special provisions relating to evidence of e-record is the heading of the section 65A. And this led to the courts to hold thereafter, and while holding such by the court, the Supreme Court held in that case that this is self-contained code. It is a special law, and therefore this special law overrides over other provisions of Indian Evidence Act also. Let us see the relationship between this section 65AB and the provisions there under 1, 2, 3, 4, 5 and the provisions in Evidence Act elsewhere, which shall prevail. And it has been explained by the Supreme Court in further cases as to section 65A wording. But section 65A provides that special provisions relating to evidence in respect of e-record. So in respect of e-record, we will follow these provisions, and other provisions may be read together unless conflicting with these provisions. We know the rules regarding interpretation of statutes. When special statute or special law and there is a general law, we say that special law always prevails over general law, and therefore section 65A, section 65B prevails over all other provisions of the Indian Evidence Act if at all there is a conflict between the two. That is wording of section 65A laid to the platform for the judgments in the Superior Court, especially in the further cases of Anwar PV and the case of Arjun Khotkar. Especially, friends, we come to the provisions of section 65B, 1, 2, 3, 4. I'll be very brief because you have well read these provisions. Nevertheless, it is relevant here. What section 65B provides? It is anything that is a printout printed on paper or any matter stored or recorded or copied in optical or a magnetic media produced by computer. It shall be deemed to be a document. What is document is defined here, and that is admissible without further proof of the original. This is admissible without further proof of the original. What conditions are required? Section 65 has made a rule. Section 65B 1 has made this further rule. Now, what are the conditions? Is it absolute that any document is admissible without any reference to any other rules? No. that is subjected to section 65(2), section 65(3), and section 65(4) of this act. But these three subsections provide, and these subsections provide for conditions, especially that provides that such computer is used regularly for lawful part and having lawful control, information is regularly fed, and there is ordinary course of activity provided under lawful control. If there are two or more computers, they are interconnected, then that is said to be a single system for the purposes of reading of these provisions. Then if this is so provided, there is electronic evidence, as also all conditions are satisfied, then issue comes as to certificate. Somebody has just now posted that what are the conditions and whether there is a format given or not. And you'll find the ARC Industries case, the Honorable Supreme Court has laid down the format itself. But I'll give the highlights, not the entire judgment part. In ARC Industries, the format of the certificate has been given by the Supreme Court. Let us see the gist or the summary of the certificate. Especially you'll find, in case of certificate, person giving the certificate shall identify what, or otherwise it will become very difficult. Say for instance, there is a Reliance agency, Reliance Industry. They are having their offices throughout country and abroad. And say in Pune, for instance, there is some office. And then issue comes as to from this office, some document is produced and that is to be put before the court. Is Mr. Ambani himself sign its certificate? There is no need. Who shall sign is stated in subclause 4 of this act. And that says person who is identifying the electronic record, the giving of such particulars regarding electronic instrument and record, and that is to be signed by responsible officer holding that position sufficient to certify. And lastly, he has to say, based on my knowledge and belief, this is sufficient. So necessity of certificate is there, but necessity is for secondary evidence. Such a document, such a certificate, as per section 65(b)(4) is necessary in respect of secondary electronic evidence, electronic record, and not for original electronic record that is to be seen. Especially you will find in case of Arjun Khotkar versus the case of Kailash Gorental, this issue has been set rest. But to conclude this issue, I will take you through cases how there was confusion in the Supreme Court. There were two judges benches of the Supreme Court holding contrary, and sometimes even like Shafi's case, there was ignorance of the earlier decision of the court. We'll go through a couple of cases to earmark how the law has been developed from the first case to the last case. And especially the first case on the point is with reference to State versus Muhammad Afzal, decided by the Supreme Court in the year 2003. This is the beginning of case law on this issue. Especially in this behalf, there was a computer generated e-record in evidence was whether it is admissible or not was the question, and has been held by the Supreme Court in this earlier case. This is rather innovative aspect that such electronic record is admissible in evidence either as a primary or a secondary depending on its nature. Then came the next case, which has been subsequently overruled by the Supreme Court. The next case is in respect of the state of NCT Delhi versus Navjot Sandhu versus Afzal Guru versus the Parliament attack case. We know that case of Parliament attack. That was decided and reported in AIR 2005 Supreme Court, page number 3820. In this case, issue was again with reference to the admissibility in evidence in respect of the secondary evidence in the form of the data in the mobile, whether that is permissible or not. Especially from mobile data, there were texts from the mobile copied and they were submitted to the court. Issue was whether this kind of evidence is requiring certificate under section 65(b)(4) or not. And ultimately, in this case, the court has held that if there is evidence of the nodal officer given, then there is no need of the certificate. This case, friends, has been overruled by the Supreme Court in respect of Anwar PV versus PK Bashir in the subsequent case. Anwar PV's case has been decided by 3 judges. In this case, which is reported in All India Reporter 2015, Supreme Court 180. In this case, it is held by the Supreme Court full bench that special provisions as to digital evidence and there is overriding effect given over other provisions. Section it is provided here that such a certificate as required under section 65b4 is necessary for production of such evidence. Then there was a subsequent case provided was the case of Shafi Muhammad versus State of HP 2018 volume number 2 SCC page number 801. However, this case which was decided by 2 judges bench and holding that in such a case, such a certificate may not be necessary. This case has been overruled by the Supreme Court because this case is said to be per incurium. What is per incurium? Shafi Muhammad case was decided in the year 2018, decided by 2 judges. Anwar's case was decided in the year 2015, decided by full bench of 3 judges. Then, if the court of a lesser strength fails to consider the earlier judgment, then that becomes ignorance of the court. And therefore, that is bad in law, but for the reason of ignorance. Per incuria means the ignorance of the earlier judgment, judgment delivered in ignorance of the earlier decision of the Supreme Court or the binding precedent is said to be per incurium. Shafi Muhammad's case is said to be per incurium, just not considering earlier binding precedent of the Supreme Court, but subsequently overruled by the Supreme Court. Then there was very controversial decision of the court in the case of Tomso Bruno versus UP, reported in 2015, volume number 7, SCC, page number 178. Case was decided by 3 judges, and in this case also, the P. Anwar's case has been followed, but nevertheless, issue as to certificate was not properly considered by the Supreme Court. And then, as we have said, 2 judges, and different case in Navjot Sindhu's case, then P. Anwar's case, Shafi Muhammad case, Tomso Bruno case, and therefore there were conflicting judgment. Therefore, reference was made to the larger bench, and larger bench was constituted. And this larger bench was in the case of Arjun Khotkar versus Kailash Gorental and others. In this case of Arjun Khotkar versus Kailash Gorental and others, this was the case, as we know, regarding the elections held in Jalna district in Maharashtra state, and has been decided on 14 July 2020. This case has been decided on 14 July 2020. This controversy has been set rest. What controversy? Whether certificate is necessary or not in the beginning, or whether without certificate there can be oral evidence given or not. There is interesting judgment delivered by Justice Goyal and Justice Uday Lalit of the Supreme Court that if there is no certificate produced, then oral evidence may be given. Now, this issue, as in Shafi's case, has been set rest by the Supreme Court in the case of Arjun Khotkar, and it has been held in 3 sentences. If original is produced, no certificate is necessary. If original evidence like our mobile, CCTV, or say any your computer, anything is taken and put in the court, then there is no need of the certificate. Certificate is necessary in that case when that is a secondary evidence. In respect of secondary evidence, such a certificate will be necessary. That is the consequence in respect of this case as decided by the Supreme Court. This is the ultimate law on electronic evidence. And according to me, this is a good decision delivered by Justice Nariman of the Supreme Court and has been supported by other competent judges of the Supreme Court. Friends, that is how we have reached the end point, the terminating point, which has been decided in just last month, especially in the Supreme Court of India, in Kailash Gorental case on 14 July 2020. Friends, with this, I come to the end. I am concluding with the remarks. I am very thankful to Senior Alange sir, as well as my colleague Amit Alande sir, and I am also thankful to all of you by remaining with me for such a long time. Usually you will find, friends, when Britishers came in India, they provided for having a lecture of 45 minutes. Why for? We have studied in colleges and schools 45 minutes. Why 45 minutes? Friends, they then conducted experiment on Indians, or even others also. What was their experience? For 45 minutes, the speaker like me and the audience like you are sincere and we are alert. But as time passes, our concentration comes down. And therefore, they said it is enough if it is for 45 minutes. Friends, I have surpassed that limit given to me, and therefore, I'm very thankful to you, all of you, for hearing me for such a long time. Thank you very much. I will conclude with a note that, friends, nowadays, the situation is very grave, and therefore, I request all of you, stay at home, follow not the social distance, but the physical distance, and also have the sanitation, and be safe and keep others safe. Thank you very much.
धन्यवाद सर. आपण वेळात वेळ काढून आमच्या विद्यार्थ्यांना मार्गदर्शन केलात. गेल्या 2 तास कंटिन्युअस आपण लेक्चर देत होतात आणि मी मंत्रमुग्ध होऊन आपलं लेक्चर ऐकत होतो. इतकं तुम्ही बारीक आणि लेटेस्ट सायटेशन्स, रेफरन्सेस, आपला अनुभव शेअर केलात विद्यार्थ्यांना. त्याबद्दल मी पुनश्च एकदा मी आपला आभार मानतो. Once again, I would like to thank on behalf of Alange's Law Classes, to thank to Mr. Avhad sir for taking out time from their busy schedule and enlightening us with the knowledge. And also I thank to all students present here for paying your attention and learning. Once again, I would like to thank all of you. Thank you, sir. आभारी आहे आपला. आपण वेळात वेळ दिलात. धन्यवाद सर.
धन्यवाद सर. धन्यवाद. भेटूया सर. थँक्यू व्हेरी मच. थँक्यू ऑल. थँक्यू.